Hello, this is John Milburn for Laws 11059 Statutory Interpretation. This is week 2. Now, this is actually a repeat of the live session without other participants, and I apologise for this being different to the normal situation, but I had some technical issues. So please bear with me during that process. You've been very patient with me. I should explain that for the first week, I was completing what we call the bar practice course, which is the course necessary for admission as a barrister. So as from this week, I'm a barrister. I had been previously admitted as a solicitor since 1984 and did my articles for a couple of years before that. So this is statutory interpretation. That's a subject which is fairly new in this sense that for example, when I went to law school back in the 70s and 80s, it was not a separate subject. There were elements of statutory interpretation that were considered in introduction to law. However, with the proliferation of statutes, increasingly over the years, the interpretation of the statutes has become more and more relevant, and hence the need for a standalone subject. The way in which I've set out the course is partly in Moodle, partly in uCrew. I'd just like to share the screen now, go through what's on Moodle, and go from there. So you should now see my second screen, and that's the landing page, as I call it, on Moodle. The layout's pretty familiar for those of you that have been at this university before. If not, I'll run through a few things by way of basics. The first is that on the left-hand side, you'll see the assessment block, and for whatever reason, the link to uCrew is there. So that's uCrew LTI. You'll see it over on the left-hand side, top of the Moodle page. If you click that link, that will take you through to uCrew, and that's where we have our general discussion. So the idea of uCrew is that that's where we have our chats. It's more interactive than Moodle. I could use a facility in Moodle, which is where generally I open a discussion topic and people can contribute. But to me, it's much too centered around me as an individual, and it's not an interactive learning process. uCrew provides that opportunity, and the idea of uCrew is that you can ask your questions of me, you can make your own comments, you can ask questions of the class, you can contribute material, or you can respond to material that's already there. So there's a whole range of different things that you can do through uCrew, and I encourage you to go there straight away if you haven't already done so. Now, the other thing on the top left-hand side, you'll see the assessment block. The first assessment is due on the 15th of December. Now, the assessment item is not there as we speak, but it will be by the end of this weekend. By the end of the 20th of November, you will see that assessment, and it will be very similar in nature to the assessment that was set in term 2 and indeed term 1 of the course. So you'll have an idea of what it is if you've had access to past papers. Assessment 2 due on the 12th of January, and then finally the briefing paper. What you will know is that, or what I guess you need to know is that I'm pretty strict, in fact very strict, when it comes to providing assessment on time. So it is very difficult to get an extension from me, and part of the reason for that is that in real life you need to have your material filed on time, and it's not possible, generally speaking, to obtain adjournments in a court context, or where you're trying to settle a commercial transaction or a conveyancing transaction or deal with an estate. So life in law is set up around timetables and deadlines, and in the training that I'm providing, which is intended to be as much as possible realistic, you will need to comply with those deadlines. The other important thing is that I have a cut-off the Saturday the week after the assessment is due. So typically for me, an assessment is due at 11:45 on a Thursday evening, that's PM, and you can then submit your work late. You pay the price of 5% per day, Up until the Saturday week, so that's 9 days later, that's when the final cutoff applies. And what I like to do is produce the results and provide the assessment feedback either on the Sunday following that or the Monday. So 10 or 11 days after you've submitted the work or the final cutoff for the work, sorry, for the assessment due for the work, you will get your feedback. So for those reasons, I like people to have their work on time. Okay, I'll provide up-to-date information in this news area here each week, and that will change. There's also a note, of course, about our Zoom sessions. So if you're watching this recorded session and you didn't participate in the first live session, I encourage you to join us live. The link is the same each week, and you'll see it there under the Zoom banner. Facebook, of course. And then you'll see the layout for the Moodle page. Read the material, have a look at the videos that I've provided, some discussion there about UCrew, the timetable for the work that we're doing. I like you to read your work in advance, and I especially like you to have a go at the problems that are set each week. So please consider doing that and staying on top of the material. There's some good work prepared there by a number of people in relation to legal research items. Commend that to you. And then some commentary about Zoom. Extensions, as I said, not easily obtained. I will invite you to have a look at the one which I like to have you set out assignment work. You'll see there's some notes there about general preference for me. This is not across the board with the university, so different course coordinators may have different preferences. I'd ask you to have a look at the John Milburn sample document down the bottom. I'll just go to that now. So this is at the bottom of week 1 of the Moodle page. So there we are. Oh, sorry, it's Introduction and General Resources. So at the bottom of Introduction and General Resources, there's a Word document. It's called John Milburn sample document. We'll just open that document now, and I'll run through it with you. And of course, it's popped up on the other screen, so we'll drag it across. All right, so the sample document, there's no real magic in this. This is my preference, but it gives you at least a guide as to the way I like to have work provided. So first thing that you see is headings and subheadings. They're taken ready from the Word program. Some slight variations. You'll see that the use of footnote referencing, and I like to tab away from the number in the footnote reference. I do that as part of my decision writing for QCAT. So I've brought that across to the university context. So I often use titles or subtitles. You can prefer headings. I use both, which is all part of the Word program. So if you're not familiar with Word or styles, it's really just this area here, and it's very simple to use. Footnoting, of course, I'm amazed at the number of people that don't use footnote referencing. It's really very easy. It's just a matter of inserting a footnote, reference, insert footnote, and that will automatically select the number and put in the superscript for you. Okay, when you're citing a case, very important, make sure it's in italics and reference the case by reference to its official reference there. So 2014 QCA 165. What else can we say? Oh yeah, when you're referring to a case, do so by the legal citation rather than the internet link. Some other recommendations, make sure that you indent a paragraph if you're quoting material, which is over 3 lines. Presentation of the work. In this particular document, I've used a Calabri 1.5 line spacing, 11 font. A few variations, a few different preferences there, that's okay. The content of the paper. Generally, I like to use short words, and short sentences. That helps the reader, and it particularly helps in introductory paragraphs. So you'll see a quote there, a couple of quotes from Lord Denning. And he really teases the reader to bring them in. So this quote here, short one: the customer pays his money and gets a ticket. He cannot refuse it. He cannot get the money back. He may protest to the machine, even swear at it, but it remains unmoved. And that was the opening line that he used in a case of Thompson and Shoe Lane parking. I thought, what a wonderful way to start a case. And even better still, much longer, is the quote that you'll see there from Miller and Jackson. Okay, so have a look at that sample document. You're welcome to use the formatting if you see some benefit in that. All right, we'll just coming back to you for a moment. I will go back to the Moodle page and talk about the work that is on there, but read it carefully and then read all of the material that's on UCrew. It's important that you do that. All right, so statutory interpretation. What's the aim? Well, if we go right back to 1904, there's a decision of Dixon and Todd. So that's 1904 1 CLR 320. And in that case, the High Court said the aim of statutory interpretation is to determine and give effect to the intention of Parliament as disclosed by the language of the statute. So what we read from that is that the first step we must do in interpreting legislation is try to give effect to the intention of Parliament. So that really talks about a subjective element. So subjective being in the mind of someone else or a particular person or a group of people, in this case Parliament. So what is meant by that term intention of Parliament? So again, if we refer to the High Court for guidance in 2002, in a decision of Wilson and Anderson, which is 2002 213 CLO 401, the High Court said this when talking about what is meant by the intention of Parliament. The words, meaning the words in a statute, cannot be considered in isolation. That is, the intention of Parliament must be determined by reference to the meaning of the words, having regard to the common law and the statutory rules of construction. So when we're considering the intention of Parliament, we must consider the common law and the statutory rules of construction in the context of reading what Parliament said. So what the courts say is that when you're considering what Parliament said, it must be assumed that Parliament was aware of the general common law position and was aware of the general statutory rules of construction. That's how we're going to interpret what they said. So we need to understand what's meant by common law, and we need to understand what's meant by statutory rules of construction. So common law, of course, is really nothing more than just a situation of identifying what the law made by judges is all about in a particular area of law. So we have statute law made by Parliament. We have the law that's made by judges, which is part of our precedent law, our case law. Okay, so where do we look when we're trying to determine the intention of Parliament? And again, for the High Court, a little more recently this time in 2011, we have the decision of Lacey against the Attorney General for Queensland, 2011 242 CLR 573. So to properly consider the statutory rules of construction identifying the statutory purpose, the court said that you must consider the express statements in the statute or by inference from its terms the appropriate reference to extrinsic materials. So what we're saying is, in order to consider the statutory rules and the statutory purpose, we have to also consider extrinsic and intrinsic materials. So an extrinsic material is something which is outside the Act. So the purpose of the statute is something that might be considered in the context of explanatory memorandum, for example, or those sorts of things. But we're really looking at the terms of the legislation internally first to try and identify its purpose. And when we're talking about purpose, object, motive, there are different rules that apply, and there are different ways of looking at this. So if we consider intention, it is not the same as purpose or object or motive. So far I've been talking about what is the statutory purpose, but you'll also see reference to intention, purpose, object, and motive. So intention relates to the meaning of the enactment. Purpose or object talks about the mischief to which the enactment is directed. And motive relates to the political reasons for legislating in a particular way at a particular time for a particular purpose. Now, all of that should be done in the context of some historical perspectives, and I'll briefly touch on that. And you might see this in the material. You might see a reference to the literal approach, or the golden rule, the mischief rule, or the purposive approach, which is really the modern approach. So just briefly, I'll go through that again. The literal approach is historically where courts have said, quite complimentary of Parliament, they've said something, they must have meant exactly what they've said, and it doesn't matter if the result of interpreting the words literally means that the result in a case is inconvenient or improbable, but they must have meant what they said. So for an example of that, have a look at Engineers case, 1920-28 CLR 129. So that was the dominant approach to interpretation. However, that literal meaning now has given way more to the purpose of the statute and the context and canons of construction. Have a look at Project Blue Sky against ABC, or Australian Broadcasting Authority rather, 1998 194 CLR 355. Against the literal approach, there were a couple of different rules historically. One was the Golden Rule, and under the Golden Rule, it said, look, if as a result of applying a literal interpretation of the statute, there comes about an absurd or inconsistent result, then on those occasions, it is permissible to depart from the plain and ordinary meaning of the words to avoid that absurd or inconsistent result. It's very hard, of course, to reconcile the Golden Rule with the literal rule. They really just don't reconcile. So the Golden Rule is the exception to the literal rule for instances where perhaps it's more than inconvenient, it's actually almost absurd result or an inconsistent result. The other exception to the rule was to consider the mischief behind the creation of the statute. It's called the mischief rule. It goes wide back to Hayden's case in 1584. But the case, Hayden's case, established the proposition that it is appropriate to determine the mischief for which Parliament sought to consider by enactment of the legislation. So the question is, why did Parliament create this law in the first place and interpret the words in the context of that ultimate desire to deal with a mischief? Now, the purpose of approach is where you consider the purpose of Parliament. It really is something that goes beyond the mischief rule, but it's aligned with the mischief rule. And the purpose of approach assumes that in some circumstances, it will be possible to adopt more than one interpretation of the language being interpreted, and we then look to the purpose. Now, really good example, I think it's in the New Lawyer, is say at the cricket, in the grandstands, the management have problems with people breaking glass, you know, drinking beer, breaking a glass, causing cuts, so they make a blanket ban. No one is allowed to have glasses at the cricket. All right, so applying that literally, we have a situation where someone at the security says to a patron, no, you can't come in because you're wearing reading glasses. you know, saying the word glasses means glasses, literal. Now, of course, the mischief behind that is not to stop people from being able to see the cricket. The mischief is to stop people from dropping glassware, drinking glass. So that's an example of where you might consider an ambiguity, perhaps, by considering the purpose for which the law was created. Okay, in order to consider the modern approach, I'm going to ask you to read one case, and I really would like you to look at this case. It's an example of how the existing state of law and the mischief that the Act was intended to address is considered. So this is CIC Insurance against Bankstown Football Club, 1997, 187384. Okay, have a look at Moodle, have a look at UCrew. That assessment, the first assessment, will be there available for you soon. And good luck with that assessment. I do encourage as many people as possible to join me for the live sessions. I'll end the meeting now, and we look forward to seeing you at the next live session. All the best. Bye.